Yes, Lord Wiltshire, we're taking us to an authority.
I was. Before I do so, I apologise for the temporary absence of my learned junior and my instructing solicitors. There is an enormous queue.
I know. It's very bad, isn't it?
And there is a very, very assiduous team who are examining everybody in minute detail. So that, I'm afraid to say I jumped the queue, which...
Did you?
But
yes.
Realising that I was on my feet. But
my juniors used to hate it when I did that.
They left a reasonable amount of time, but they will be with us.
Presumably they're... fine. Right.
So I was going to take you to an authority, and the authority is the decision for the US mortgage finance and due. The case is a long way from this. It was all about borrowing money to borrow a property in Florida, defaulting on the mortgage, and then an attempt made to try and get the money from the mortgagor. The relevance of it is the final two paragraphs referring to the well-known case of Ladd and Marshall, and this can be found at page 1011. We're looking at the second of the two bundles of authorities, where the judge says, since then, referring to what had been said in Ladd and Marshall and further to that, it's been routinely applied in this course, even in appeals from summary determination. The first consideration is whether the evidence could, with reasonable diligence, have been placed before the court below. There is, in the present case, no evidence to explain why the evidence now sought was not placed before the court below, or indeed what subsequent steps was taken to obtaining it, or when. I've said there was no application for an adjournment of the hearing on the application for summary judgment to enable it to be obtained, and it may have been a tactical decision. The second criteria is whether the evidence will have an important effect on the outcome. Mr. Higgins did say in making his application to admit the new evidence that he ought to succeed even without it. As Mr. Latterby pointed out, in itself rather undermines the ability to satisfy the second criteria required by Ladd and Marshall. In any event, the opinion of Ms. Goodner states that as regard the effect of the merger does not appear to be contradicted by a decision of the District Court in Florida. And this is the important bit. But be that as it may, the application does not, in my judgment, satisfy the first of the criteria in Ladd and Marshall. Those criteria are cumulative, but each one must be satisfied before the court will admit the evidence. So this fails essentially at the first offence, even if it does have some relevance. It may well be that it doesn't really add all that much to what was in the court chronology or the other.
Well, it doesn't add much to what's in the chronology. But the initial version is pretty close to what's in the chronology, and the second version is pretty close to what's in the shortened version, isn't it?
But experience tells me that sometimes additional pieces of evidence can be fastened on by a court, and it may be said that they illuminate some other entry, or they aren't fair, and that seems to be said, they aren't a complete summary. And that is contrary, we say, to the fairness that should be applied in this case, fairness to both sides. Returning to our skeleton, I don't think there's any argument that these papers were available in 2017. Those currently representing the claimant were not then involved, it must be pointed out, but I'm afraid that the faults of predecessors will be inherited for the purposes of this application. We make the point at paragraph 25 that the problems are magnified by the fact that we don't have a draft of the Amended Particulars of Claim. Supposing it was said that as a result of these additional documents, there are new and different matters that ought to be taken into account by the court. There's nothing to that effect before the court. The court is simply asked to look at them generally. And I think they seem to be deployed in argument simply to say that, well, all this must come out at trial. And these might be of some relevance. So, paragraph 26, the assertion that we're not prejudiced by the reliance because they were in our possession rather misses the point. Because, of course, a hearing before the court is based on the highest the claimant can put their case in the particulars of claim, and as a result of their failure to do so, of course, if you were to allow this and were it to be successful, these additional evidence, then it would have caused an immense amount of waste of time and a huge amount of costs, and that would be inappropriate. So in our submission, this application ought to be refused.
Thank you. Do you want to say anything, Mr. Jacobs?
No, I think I can stand by my submissions before lunch.
Right, well, we'll give our decision when we give our judgment. Want to continue? Go forwards.
Because of the chronology, as it were, it's been agreed between us, unless the court doesn't find it helpful, that Birmingham goes...
Makes sense. Birmingham first.
Yeah.
Happy with that?
Yes.
James? Happy?
I'm most grateful, my lord. Can I deal first of all with the care and control point? And we have made that concession.
Yes.
It was a point that shouldn't have been argued in front of Judge Avey. We've had time to reflect on it before drafting the skeleton for this appeal. We submit that the point is not consistent with established case law, but more importantly, that it doesn't reflect the scheme set out, and I think you alluded to it, my lord, in the Children Act 1989, whereby there are gradations of involvement by social services with children in the community. And I'm going to take you to some of the family authorities, which identify that as the template or the manner in which the Article 3 rights are balanced against the Article 8 rights in the community. And having made that submission, it would be inconsistent to say that those statutory powers which allow social services to protect children in the community don't give rise to a breach of Article 3. So that's the underlying rationale behind the concession.
But it does seem to me it probably wouldn't be wise for us to say something about care and control generally. You can think of lots of examples. The traffic warden standing on the street sees a man attacking another man. He sees a real and immediate risk and so on, but he's got no powers and it's not his role. Or an art gallery attendant suddenly seeing somebody rush towards another person who just likes munch or something.
I agree entirely with you. And I was going to say that doesn't mean that we think the Kent coroner's case is wrongly decided, because that is a different context. That's an Article 2 claim. It's about treatment, and so it's a very...
Well, that was exactly the point that the appellants made below. That it was an authority taken out of context.
My lord, I've accepted that. We may have become late to the party, but I hope it is a proper concession made.
Well, what do you say to what Ms. Gumbel said, that we ought to say something about it in our judgment? The care and control point. On the basis that the first instance judge's decision is reported and might be followed if we don't.
In my submission, you should restrict your comments to the operation of the Child Protection Powers in the Children Act 1989, and I think that would avoid...
So in the context of a claim involving the exercise of powers under the Children Act 1999 by a local authority responsible for a child, no additional element of care and control for the purposes of Article 3.
Exactly, yes.
Sorry, let me just put that down.
That's because it's on that basis that we make the concession. Those statutory powers are specifically there to protect children in the community. They are, as we will see from the authorities, meant to balance the Article 3 against the Article 8 rights. They would be nugatory if you required care and control. I had a child already taken into care before the obligation under Article 3 was engaged.
Yes.
I hope that's helpful.
Thank you.
Can I now turn to the point that my learned friend Ms. Gumbel's raised really in response to your questions and today about the nature of the judge's determination of the summary judgment issue. First of all, she says that the judge was infected by her finding on the care and control point. But if you look at the relevant passage of her judgment, she makes it quite clear that that's an alternative. And she decides the summary judgment point first before going on to the strikeout point second. And she starts by saying this is in the alternative. So it can't be right that one element infected the other. But secondly, and with the greatest respect, it's our submission that Ms. Gumbel confuses the two powers. One only has to look at the rules themselves to see the difference between them. 3.4 is that the court may strike out a statement of case if it appears to the court that the statement of case discloses no reasonable grounds for bringing or defending a claim. Now, my learned friend says all you need to do is look at the allegations pleaded, assume they're right. That would be correct if it was a question about the statement of case under CPR 3.4. But here we're talking about summary judgment under CPR 24.2. And the test is that there's no reasonable prospects of succeeding on the claim or issue. And so what a judge is entitled there to do is to analyse the evidence before him or her to decide whether there are reasonable prospects of success. And Judge Ovey directed herself by looking at the relevant authorities as to the appropriate test, and I will take you to one of them. And then she considered all of the evidence in front of her. And the evidence in front of her, and I restrict my comments obviously to Birmingham, were the pleadings, which included the Appendix 1, and it is clear that Appendix 1 is based upon the social services notes, which we set out in our skeleton, were served with our letter of response. And also she then considered the social services records that we had put in. Now they were the documentary records dealing with events between 2005 and 11, and the only evidence before her. And was absolutely entitled to consider that evidence and see whether or not the three propositions advanced by the claimant in front of her on that evidence stood real prospects of success. And those propositions were, 1, that there was inhuman and degrading treatment, 2, that there was a real and immediate risk, and 3, that a judge, had the case been brought in front of him and her, would have removed the children under Section 31(2) of the Children Act 1989. Those were the 3 issues she was dealing with. She was not dealing with other breaches because they were not pleaded. And I will take you to the pleadings because they take some analysis.
So the third issue, would it remove the care, child from the care, you said?
I'm so sorry.
The third issue, would it remove the child from the care of the mother by a court order, Section 31?
Would a judge sitting in the family division or family court have removed the child?
Would a judge? Is that how it was put? How would you put
well, I'll take you to...
that's just a question mark in my mind. How exactly we should phrase that? But come to that when you...
Had it come before a judge, would a care order have been made? Might be a more eloquent way of putting it.
Would a care order have been made? Yes. Okay. Would a judge have made it? Okay, fine. Well, I think I just want to... When we get to that point, slow down a bit because I want to think about that particularly.
But my lord... The importance of looking at the records is illustrated in the first event. And if I could just take you first to the core bundle and then the supplementary bundle. So in the core bundle, in the appendix, the first event is the occasion when it's said that baby's hair was dyed.
I'm so sorry, Mr. White. Just tell me that page number again.
96, please, my lord, in the core bundle.
Yeah. Thank you.
And it's the second entry in the table, and it's an anonymous caller alleging that mother was neglecting the child. And you can see what's there set out. If we could then go to the supplementary bundle.
Line 3 of that entry.
Mm-hmm.
I don't want to say anything that might identify anybody. Is that the right word? You see the last four words of that line?
I think that's a wrong transcription. Oh no, if one looks at page 77 of the supplementary bundle, please, my lord.
Okay.
You can see reasons for initial assessment halfway down the page, please. And you can see there is a caller who is anonymous, who gives a very damning description of the conditions, and then you have a report
Yes.
which is separate to the initial allegation.
I see.
But if we could turn the page, we can then see the initial assessment, which is carried out thereafter. And I don't want to go through it in its entirety, but if we look at the bottom of page 78, penultimate paragraph, following this referral, a home visit was made to share and discuss this referral.
Careful with the name.
Yes, with mother, was open, and she stated someone else was living there, but the child was not left unsupervised alone with her. The house was seen. It appeared clean and tidy, with all basic equipment furnished appropriately. Child's bedroom was seen. There were lots of toys seen and appropriate for child. Kitchen was tidy, food seen. Child seen, hair not bleached, no burns on neck or ears. Dressed appropriately, good relationship with mother. And then at the bottom of that section,
I feel this child is not in need.
yeah, under section 17.
Yeah.
And so, my lords, if the judge on a summary judgment application had simply looked at the entry in Appendix 1 that I've taken you to in the call bundle and ignored the investigation by social services, it wouldn't have reflected the facts on the documents, because it is always the case that there can be concerns raised, investigated by social services, found to be unfounded.
Yeah.
And doing her job as a judge, exercising a summary jurisdiction, she took into account the totality of the evidence, which is what she was required to do. And again, the appellant here can't complain because there was plenty of opportunity, albeit obviously not by his present legal team, to respond if the notes provided an alternative scenario. And in the call bundle, we have provided a chronology. It's our chronology, but I think it's agreed, 29 to 31. And you can see that are at page 30, the statement of those instructing me, acting for Birmingham, with the social services notes attached, was provided on the 19th of August. There was then the issues over clarification from the Part 18 requests, but nothing further other than further iterations of the pleading from the claimant. And then the hearing was on the 18th and 19th of November. So there were an opportunity of several months in which further evidence could have been adduced and relied on. And the conclusion must either be that there wasn't any further evidence which changed the position, or simply the claimant didn't wish to rely on it.
But just looking at a summary judgment and avoiding a mini-trial, it's obvious there's a reference to the father there, but no one adduced any statements from him or said they wanted to adduce any statements.
And if one follows the chronology through, he dropped out quite quickly.
Well, I saw that.
And of course, what my learned friend has said today is that the further evidence would be one, expert evidence, and two, evidence from the social workers.
But the expert evidence can't be relevant to whether or not the child's hair was or was not bleached.
My lord, that's absolutely our point, and I'll address you on that in a moment if I may. Can I just deal with social workers?
Yeah.
First of all, 3 points. If the social workers were to come, giving evidence 10 or 15 years later about what, as my Lord Baker identifies, is not an unusual situation, the reality is that the only recollection they would have is in relation to the notes. They will likely say, these are my notes, this is what I can tell you about the event. Secondly, it is not incumbent on the second defendant to call them in any event. Thirdly, if one looks at the case of Z, on which my learned friend relies, one can see in the findings of the Commission, which we discussed before the short adjournment, at C91, page 252,
Right. So that is tab.
Tab 12, my apologies.
Yes. We looked at C95, or I did.
Yes, could we look at C91, please? Bottom of page 252.
Yeah.
You can see there that the government states that the allegations of treatment were not tested by cross-examination. The Commission finds that government has not sought to call into question the reports made. And so, in some senses, the situation is comparable here. While we're in that judgment, because I don't wish to return to it, it is worth noting that the psychiatrist, Dora Black of the Tavistock, indicated that this was the worst case of child cruelty or neglect that she had encountered. And I rate that, of course, because my learned friend says that this and that case are comparable.
Where did she say that?
I'm just going to find that reference. Will you bear with me a second, please? 278, I'm told.
I don't have these 278 and 2. I got page 1881 at the bottom and the actual numbers at the top. So.
Well, I'm very sorry about that.
Oh no, sorry, that's because I'm in the wrong case. That makes a difference.
Usually. So, where's Dora Black's comment?
Para 128 is that?
Sorry, it's actually
I think, oh, yeah.
page 241, it's paragraph 40 of the judgment.
Thank you, my learned friend. I'm very grateful.
Ah, yeah.
Yes, it's paragraph 40. Dora Black, consultant child psychiatrist. To put it bluntly, horrific. The worst case of neglect and emotional abuse that she'd seen in her professional career. So with the greatest respect to my learned friend, I don't think the comparison between this and the facts of this case, that case is opposite. The final point I would make about social work evidence, and this goes to expert evidence as well, is again in part in relation to the pleadings. But could I take you to Judge Obi's judgment, please, at paragraph 61, page 60 of the core bundle? If one looks at the bottom of this, she says other imperfections in the formulation of the article of reclaim include 1, the absence of any Part 35 compliant medical report supporting the alleged psychological injury, post-traumatic stress disorder, borderline personality disorder, and a contribution to Asperger's, and 2, the inference the court would be invited to draw. Now, in the appellant's skeleton, it said that those inferences relate to the psychological evidence. With greatest respect, I think that's a misreading of the judgment. She is identifying 2 different problems in the way the Article 3 claim is formulated. And we can see that by going to page 61, paragraph 63. And halfway down it says, however, Mr. Cotnell submitted that a social services report is often not the whole picture. At trial, the court will be invited to draw appropriate inferences and join up the dots based on the reports and assistance of an expert evidence independent social worker. Although there may be some force to these observations, the inferences the court would be invited to draw have not been pleaded in any version of the particular claim. As currently drafted, taking AB's case at its highest, it is the 11 incidents between 2005 and 2014, either individually, and she notes there that it is cumulatively, which must meet the Article 3 threshold. So first of all, the criticism about inferences in the appellant's skeleton is misplaced. But secondly, if there were issues on the documents which further evidence could clarify, what those issues were was never identified before the judge, and in my respectful submission, neither before you today. Can I turn to social work expert evidence and address Lord Justice Lewis's question? And I'll hope to support this by going to the pleadings in a second. But there were 3 issues that the judge was asked to determine on the pleadings. 1, had there been inhuman and degrading treatment? Had the minimum threshold for severity been passed? 2, was there a real and immediate risk? 3 should C have been removed. There were no allegations of breach against social workers. And by that I mean breach in the sense of inappropriate, negligent practice when applying the Boland test. And there were no such allegations because, at least as argued in front of the judge and in my submission as argued here, if you establish the first two limbs, human treatment and a real and immediate risk, then the question of whether it should come before a court or not is largely determined. To do the counterfactual, if I were to submit, well, you've proved the first two limbs, but there's no evidence advanced that social workers were negligent, so you haven't got a causal connection to removal. My learned friend would say, well, if there's been inhuman and degrading treatment and they know of a real or immediate risk, of course the step is to consider whether there should be removal or not. Certainly that appears to be the way it was argued in front of the judge below. Dealing with social work expert, the reason that social work experts are entitled to give opinion evidence, because that is what it is, they're looking at the records and saying, what would we do? Is because based on their professional expertise and experience, they are entitled to advise the court, applying the Boland test, on what appropriate social work practice would be. Now, in our submission, that is irrelevant to the three issues I've identified, and it is certainly irrelevant to whether a judge would have taken the child into care applying section 31(2), because that is a judicial decision. You don't have a social worker advising the judge. It is a matter for the judge to determine, and it would be a matter for the judge to determine here, just as in a...
Well, that's why I've honed in or focused in on the third question, which you've now said, should the child have been removed? Is that the question, or is the question, should the local authority have applied to court for the child to be removed?
I understand that section 31(1) requires the application and it's a local authority to apply. And the way the pleadings are phrased in this case is that under Article 6, there should have been an application to remove.
Yes.
Under Article 8, the judge would have removed. That's the pleading. Now, in my submission, if you've established the first two limbs, inhuman and degrading treatment, and the real and immediate risk, all a court is likely to consider in this context, as opposed to the common law context, where you have to establish negligence, is whether or not there would have been removal.
Sorry. Whether or not a court in these proceedings would have to ask itself whether or not there would have been removal.
Yes.
But that would depend on what the family court thought of all the evidence.
It would indeed.
And there are two questions, well, there are many questions, but the two principal questions are, first, is the threshold crossed? And secondly, if the threshold is crossed, what order to make? And there are many cases, particularly at the interim stage, where the interim threshold is crossed and the child isn't removed. In fact, there are further hurdles to go, which have to be gone through. But that's why I'm wondering whether the question is not whether the child would have been removed, whether the local authority should have applied for the child to be removed.
Well, in my submission, that would be right if that were a common law claim, because what you're alleging is negligence of the social workers. But in an Article 3 claim, you are saying, 1, inhuman and degrading treatment, 2, real and immediate risk, 3, if those conditions are satisfied, would the court have removed?
Well, I do wonder whether one oughtn't to actually look at what the European Court says, and for a positive obligation right, it must be established that the authority knew or ought to have known at the time of the existence of a real and immediate risk of ill treatment 1, 2, and 3 of an independent individual, and that they, the defendant here, the local authority, failed to take measures within the scope of their powers which judge reasonably might have been expected to avoid the risk. So it's what powers have they got? Would they reasonably be expected to avoid the risk? So they should have taken them. So it's putting this into that. It's either the application, they should have asked the judge, or ultimately, and if it's a local authority, perhaps it is, should they have applied for it. But I suppose you would say, if the judge would not grant it because the criteria were not met, then it can't be something within their powers. They couldn't have done it to avoid the risk. I don't know where you get if there's questions after the criteria.
Yeah, I mean, obviously a judge could have made an interim order. The judge could have sent it back and made directions as to further hearings. And in fact, I know two of you sat on the HXA appeal where you considered the case of DFX. And precisely this issue came up in front of Mrs. Justice Lambert, and my learned friend and I did that. And certainly her position was, I have to decide what the court would have done, but I can be advised by social work experts who were called in that case to consider the actions of the social workers and their breaches. And if I can refer you to that case, which is in your, I'm afraid I don't know where the binder's split.
Tab 46, HXA?
HXA.
So 243, I think.
I've got it at tab 43.
Sorry, I missed that tab.
43, my lord.
I apologise for my cough.
No, no.
46.
43, my lord, tab 43.
Tab 43.
Yes.
46 in mine.
43 is Curtin, Australia.
It's 46 in mine.
Well,
46 is another European.
I've got DFX at 43.
Can I give you a page number and see if that works?
I've got it at 47. Try 47.
What about page 1374?
1491.
1491.
Okay, well, we'll have to do a bit of mixing and matching, my apologies.
You're after Mrs. Justice Lambert's judgment?
Yes, I am.
Oh, I thought you were after
sorry, but you're after
HXA.
HXA?
No,
It's all right,
sorry.
I looked across there on the
Yeah,
corner.
my fault.
That is 43 and is 1374.
Thank you so much. If you look at page 1424, she deals with the issue of breach. And at paragraph 213, she talks about the claimant's expert, Miss Ruger. So Miss Gumbel's case in breach of duty focused upon the events and decisions in 2002 and 2003 and 4 taken by social workers. Miss Ruger criticised the adequacy of Mr. Dack's core assessment, the decision of the Child Protection Committee in June 2002, the court proceedings did not need to be initiated, the failure to issue care proceedings 23, and the efficacy of the direct work undertaken by social workers and family support workers in 2002 and earlier. So there you would have a social work expert to offer that expert Bolan criticism or commentary on what the social workers did. But that's not what this judge was trying to decide. This judge was trying to decide what a court would have done. And if we take you to the pleadings in the core bundle, I hope I can illustrate. Starting at page 84, we can see at page 87 that the common law claim against the second defendant has been deleted, but one can see there that the allegations continue to manage the claimant's case with him remaining in his mother's care. So that is a criticism of the social work undertaken. We then go to paragraph 7, which says, whilst in the care of his mother, the claimant was subjected to inhuman and degrading treatment and punishment at the hands of his mother and other adults of the kind prohibited. The defendant knew or ought to have known that the claimant was or might be being subjected to such ill treatment upon receiving the following report. And the 7 items are there set out. And then at 8, and we're dealing with A, not B, failed, and we can take out the first 2.5 lines because they deal with the investigatory breach. failed to remove the claimant from his mother care in breach of the operational duty under Article 3, the claimant lost the opportunity of being removed by the second defendant from about July 2008. If removed, the court would have had a 50% chance of a successful adoption. In the alternative, he would have had successful long-term family or foster placement. So in my submission, and then it goes on to identify the same point at Roman 2 over the page in relation to the first defendant, albeit later in time. The pleaded case was a court order. And certainly that's the way it was argued and how the judge approached it.
Just to fill in the gaps in my knowledge, a successful foster placement, that wouldn't have been required to have a court order first, would it?
Yes, you can certainly place a child in foster placement while awaiting a court order, but normally the position will be that there will be a court order if it's a long-term foster placement.
So there's placement orders, it's what is meant there. So this all involves, once he's removed from his care, it's not putting him in Section 20 accommodation.
No,
it's got to be...
You could do that for a temporary period, but to leave a child, particularly at this age, for a long period under Section 20, the case law would say might be a breach of his Article 8 rights.
But
you're summarising a whole day's worth of case law.
I accept that, my lord, but I try to answer
happening all over my race bits.
Well, because Article 3 is real immediate risk and the steps necessary to remove that risk. And we're switching, it seems, in this court sometimes from there's a risk, high duty on the state if it's a risk of really bad treatment, to move in and eliminate that risk. We seem to be switching from there, saying, right, what will happen to him for the next 5 years? That may be what the family lawyers are concerned with. Maybe the right thing for the child and society to be concerned with that. But I just wonder whether Article 3 is different. But you're saying, read reasonably, this is all about a court order. And if a court order wouldn't have been granted, then there can't have been an Article 3 breach because there wouldn't have been steps they could have taken.
Well, no.
No? Oh, right.
That's how this case was argued.
Right.
I can see that you could argue it differently and say, as my lord said, there's an escalating level of interventions under the Children Act 1989. So you could have said you didn't provide Section 17 support to the family. In fact, if we look at the notes, that did happen. You didn't carry out a Section 47 investigation, which would have put the child on the Child Protection Register. Support could then have been provided to the family. You could have had all of that, but that is not this case.
Yeah.
This case is about removal.
Yeah, I mean, but the local authority can't remove by itself.
No.
It can only remove with consent or with a court order. So the most it could have done would have been to take all necessary steps to remove. That's really what how we must read the pleading, isn't it?
But for the claimant to succeed on his causative case, the court then has to make the order. And on the summary judgment application and on the pleadings, what the judge was asked to decide was, would the court have made the order?
Well, you see, this is, I mean, again, I may not be helping, but this is, you can't say that. It's difficult to say that because it's a decision for a judge, and the judge makes a decision on the totality of the evidence.
Yes.
Having provide the welfare principle and takes into account all sorts of issues, including the views of the children who are represented by the guardian, and may make a decision which is not in the local authority's hands.
No, I agree with that entirely, which is why I say because it's a decision for the judge, it's not one for which you need a social work expert, which is the narrow point that I was addressing.
I follow that.
I mean, I accept that these pleadings are inadequate. I accept that they don't properly set out the chain of events, but I'm defending Judge Obi's judgment, which dealt with the case as it was presented to her on Sunday. And again, I adopt what my learned friend Lord Folkes has said, which is that there have been no new particulars of claim in front of you, identifying that sequence of events.
So for Article 3 purposes, you're not going to have social work evidence of what was or wasn't reasonably appropriate. You're going to have to decide as a court whether or not there was a breach of Article 3 and whether we say took steps to initiate an order or got the order. That's what we have got to decide to the court. Is that it?
And that's how a European court would approach it as well.
And that's what...
So for instance, in Osman, you don't have an expert policeman say, this is the position of risk, nor in DP or UK.
But if the case was to go to trial,
yes,
you're saying there wouldn't be an independent social work expert evidence.
I'm saying if the case went to trial as presently constituted, you wouldn't need one. If the case were to go to trial and the escalating level of social work involvement was said to have failed, so that maybe they should have carried out Section 17 support, maybe they should have carried out the direct work, as was the case in DFX. It was said there was a failure to carry out direct work with the children.
Yeah.
Then, of course, those are actions of a social worker, and you need the social work giving expert evidence based on their professionalism and expertise to carry out your Bolam assessment. But nowhere here is it pleaded that there's a duty of care on a local authority, applied a Bolam test, which is precisely what you would have expected to see, what my learned friend pleaded in DFX. So I am dealing with the facts of this case. I'm not saying in an Article 3 claim you will never have expert evidence.
In an Article 3 claim which requires removal of the child by consent or by court order, it's not necessary because the court decides whether or not the failure to initiate the removal by consent or court order.
It's a matter for the court, that, because it's a judicial decision, and you can't have expert evidence of what a judge would have done.
Yes, I'm struggling with it. How it's been argued is not how I'm naturally thinking about it, because the decision whether or not a judge would have made a care order is not a matter for expert evidence. It's a matter for a judge. But the decision whether or not the local authority should have started care proceedings is a matter, I think, on which you could perhaps have expert evidence.
I agree.
I mean, take an obvious example. If there was a case of a very serious child, or sexual abuse case, and the local authority decided just to deal with it on a Section 17 basis, then that's something which expert evidence could say was wrong practice.
Yes, and in DFX, they had a child protection meeting. Children were placed on the register with a plan to remove. 4 months later, circumstances had improved in the family.
Yes, that's right.
They decided not to remove. That's absolutely proper for expert evidence, I entirely accept. But you can't criticise Judge Obi for deciding a case which wasn't before her.
Yes,
Which is what I suggest my learned friend is doing.
Okay. Thank you.
My lords, we have another 6 incidents. I can go through each of them if it's helpful, looking at the records where relevant. But our submission is that none of them meet the threshold for minimum severity. Individually, all cumulative. And an important point on the cumulative nature of this is the pleading that I've taken you to at paragraph 8, which says from July 2008.
Yes.
So the first 3 incidents predate, and the last of those incidents is some 20 months before July 2008. So if you're looking at real and immediate risk, you have a 20-month lacuna where there are no concerns. Then you have another 4 incidents. Only one of those incidents involves an allegation against the mother. The child is seen. There is an investigation. The charge says he was injured by his mother, but it was accidental. Then you have can we go to page 89, and I can deal with these quite quickly. July 2005, you can get all of this from the appendix. In July 2005, the child went to stay with his father. It was reported that Miss L, who had been babysitting, had bruised him. The father was in Yorkshire. There were investigations in Yorkshire, including a police investigation, where he said that mother's partner had bruised him. Mother had told social services when she found out of the allegation about Miss L that she wanted her done for this. There was an examination in Yorkshire, and the GP found that the bruising, there were 3 bruises, couldn't be said to be not accidental. Inconclusive is the words used in the notes. The child was returned to mother. It was noted that Miss X, who is the lady who there are concerns about, was in the household, and an agreement was entered into that she would leave. Miss X had not been alleged to have caused a bruising. The concerns about Miss X were not sexual, but that she had a child who may have been physically at risk, and that was being investigated. In 2006, in February, and this is in the supplementary bundle, there was a report by the maternal grandmother
So what we've got then, we've got non-accidental bruising.
Yes.
And one alleged perpetrator, or
Two alleged perpetrators.
the other being Miss
Miss
Ellen,
L, who'd been babysitting, and mother's new partner.
Miss X.
No.
Oh no, the new man. Yes.
New man, exactly.
New man.
Not Miss X. Miss X was staying at the property. Miss X is not alleged in that period to have carried out the attack, have carried out an assault by the child. Then in February 2006, if we look at the supplementary bundle, you have an allegation by the maternal grandmother who lives in Anglesey, which we see at page 84.
Don't give the areas. There's not a lot of people in Wales.
My apologies.
Page 86, is it?
84, Mike.
84, sorry.
We see it at the bottom, reasons for initial assessment. There is then an investigation, and we can see it summarised at page 86. At the bottom of that box, there are no concerns. And again, if you look at workers' recommendation on page 87, please, my lord.
Yes.
At page 91, there is the next instance, which is an anonymous referral, again, in October 2006.
Sure.
That is not investigated. It's raised with a manager, and we see on page 92, given the two previous unsubstantiated anonymous allegations, it was considered to be malicious. And there is no evidence of neglect in the subsequent 20 months, although there was a health visitor and he was at nursery. If we then go to page 94, please.
So just to make sure I got it right, the three incidents that are actually pleaded. One is the bleach, where the report says it didn't happen. One was the bruising, and it's one of two people we think, but that was in Yorkshire, and perpetrator couldn't be identified, but it wasn't the mother, and it wasn't Miss X who was there. And then the third one was said to be an anonymous malicious allegation. That's all we've got prior to 2008, is it?
Yes.
Right, okay. And then the 20-month gap, yeah.
Then the 20-month gap, and then we see in July 2008, it said that Miss X had struck C with mother's consent, and we see that set out at pages 94 to 96. And there is then an investigation, which we say at page 99. Sorry, my apologies, the investigation is at page 102. And in effect, what is found is that mother is having problems coping. She has had another child by this point. She's doing an MVQ course at college and finding combining that and looking after her two children stressful. She'd been staying with Miss X, who had disciplined the child, the claimant. There's no bruising. She leaves Miss X, who by that point is looking after her own children and so can't any longer be Schedule 1. And at this point, if we look at page 105, my lord, we see that the child is found to be in need under section 17. And support is arranged in the form of the family centre, a neighbourhood care scheme, and liaison with the health visitor. And if we go to page 106, we can see that reference to other agencies is made as part of the initial assessment. The next entry is dressing in women's clothing, and there was a report from the school that had happened. So there was a report, someone had taken a picture, someone had been sent a picture of it. The child looked distressed, it was sent to social services. They went to see the mother, who accepted she'd done it. She didn't seem particularly apologetic. They went to see the child at school. He said he had been dressed up, sometimes he liked it and sometimes he did not. And we find that reference at the top of page 108. Looking at X, asked if he plays dress-up games. He said that his mum does dress him up, and sometimes he likes it and sometimes he does not. The final event...
And isn't that, Ms. Gumbel would say, example of something that's a real and immediate risk?
She's saying first it's degrading treatment, and secondly, because it is degrading treatment, it gives rise to a real immediate risk. And that's another debate we need to have about the judgment, because there's criticism of the way the judge approached the question of real and immediate risk. My submission is that, in fact, what she's saying is, if your case is that there are Article 3 breaches, then there is real and immediate risk. She's not saying that I have to know about future breaches. It's enough that they may occur.
The fact that breaches have occurred may be strong evidence that they may occur in the future, thereby being a real and immediate risk. The fact they haven't occurred wouldn't necessarily mean there wasn't a real and immediate risk, but then you'd be looking for other evidence to show a real immediate risk. But given that this has happened, she's taking photographs of a child, she's dressed up in women's clothing, the amusement of others, and the child sometimes doesn't like it. Ms. Gumbel would say, why isn't that evidence that on an occasion, and as you said, the mother wasn't apologetic and didn't show remorse, why isn't that evidence of a real and immediate risk that she might well do this again? And that's humiliating to the child.
Because, my lord, if one aligns the Article 3 with the family jurisprudence, it's absolutely clear that this, as the judge found it, was an example of bad parenting. And bad parenting, as is indicated in DP, is not sufficient to pass the minimum threshold. Because if it were, to come back to my Lord Justice Baker's question, this is not unusual. You'd end up being in a position where there would be constant Article 3 breaches, constant real and immediate risks, and constant intervention by social services giving rise to breach of Article 8 rights. Context is all. And I'll address that point as I go through my submissions. The last incident is that C has been slapped by a babysitter on the November 2009. This did happen. It doesn't leave a bruise. Mother reports it to the police. The police investigator, because it hasn't left a bruise, don't take any action. The police tell social services, and social services write to mother saying, you correctly reported it to the police. We'll take no further action. Be more careful, I think, with who you leave your children with. And we see that at page 110 in the form of the letter sent to the mother to social services. So my lords,
There is a sort of pattern emerging by this point, isn't there, of a woman who's content to leave her child in the care or put her child in a situation where the child is harmed by other people.
well, I'm not sure I'd accept my lord's submissions. There are 3 instances.
Yes.
One where it's not proven that the injury is non-accidental. One where there is chastisement by Miss X, which doesn't leave a bruise. And one where a babysitter chastises and doesn't leave a bruise, and one reports her to the police.
Yeah.
And
I'm not making. I think I can imagine in some cases, some local authorities might take a slightly different approach at that point. But that's not fatal to your case, that observation.
My learned junior reminds me very importantly, and I apologise, the last incident, November 2008, is not the claimant but his brother, who is slapped by the babysitter.
Well,
It's leaving children.
I accept that, but it's an important detail and the court should be appraised of it, of course.
I just think some local authorities might have taken a different course at that point. That's all I'm saying. It doesn't.
So this is 3 incidents over a 6-year period, 2 of which don't leave visible injuries and 1 of which does, the first one.
If it is in fact an incident, because of course the medical report is inconclusive. And to be fair, I think the judge, if one goes to page 65, paragraph 76, the Judge Obi echoes what my lord said. Yeah. She says the social services records represent the high watermark of AB's claim. The mother's ability or willingness to protect AB from physical chastisement from others was inconsistent. Regrettably, there were also occasions when she appears to have demonstrated poor caring and nurturing abilities. Cumulatively, the picture presented by the detailed chronologies of a variable standard of care. There is nothing within BCC's records which come close to alerting BCC to a real and imminent risk that AB will suffer significant harm amounting to Article 1. And she also identifies each of the incidents, considers each of the incidents to see whether they pass the threshold. And she approaches it in 2 ways. And she does so, we can see in her introductory section, by first looking at punishment, and my learned friend took you to that in the reference to Tyra at paragraph 31. And the way the judge has characterised it is absolutely correct. My skeleton fails to do so. It's my mistake. I apologise. But she was there considering punishment in that context. She considered, as both of the parties have, the case of VK versus Russia. We see that at paragraph 30. And she cited from it at the top of page 52. And that was a case where a young child in a nursery had been very badly treated in both an inhuman and a degrading way. And she quotes at the top there from paragraph 168, treatment had been held by the court to be inhuman because it inter alia had been premeditated and implied for hours at a stretch and caused either actual bodily injury or intense physical and mental suffering, and also degrading because it had been such as to arouse in victims feelings of fear, anguish and inferiority capable of humiliating and debasing them. In order for a punishment or treatment associated with it to be inhuman or degrading, the suffering or humiliation involved must be, in any event, or beyond that inevitable of suffering or humiliation connected with a given form of legitimate treatment or punishment. So she's there dealing with punishment rather than treatment. And she identifies properly the authorities and the level.
So and the United Kingdom was also a punishment case because the stepfather was chastising the child.
Exactly.
Right, so that's all about punishment, yes. Then you say.
So in A, the child was 9, the stepfather beat him with a garden cane over a period of time because the bruises were of different duration. There were 4 different types of bruises identified, some more serious than others. In Costello Roberts, he was hit 3 times over his buttocks wearing shorts at the age, I think, of 7-year-old, you see there. In your bundle, you also have Y, where again a child was beaten with a cane by a headmaster, and that was found to be inhuman degrading treatment. So where punishment is concerned, you have injury using a weapon, if I can put it that way, or at least a stick, in Tyra, A and Y. In Costello, a soft soled shoe doesn't give rise to it. But in some sense, all those depend on their facts. The formulation is in VK, which she cites. But in our respectful submission, this isn't really a punishment case, because although there are occasions when it may be that there's slaps for chastisement, this is really a case, and I think my learned friend was advancing on this basis, particularly if it's cumulative, of bad parenting and neglect. And the judge went on to consider that when looking at some of the family judgments, and she also went through the relevant sections of the Children Act 1989, looking at the increasing level of involvement. And it is clear, for example, section 17.1, that the local authority should try to support the child in the home so long as it's feasible to do so. And we say that if you are looking at this case, which is all about neglect, either in instances or cumulatively, you have to take into account the context, because the European Court requires you to look at context in relation to both the threshold and real and immediate risk. And we say you get that, first of all, from Limbuela, which we have behind tab 17. And it's paragraph 54.
'74.
54, my lord.
Sorry.
And the first 2 sentences of 55, please. And my lord, we'd also ask you to look at our Munjaz, which is at 18, and again, Lord Hope, in relation to Article 3, at paragraph 78, 504. And we rely on that to identify that where what is being dealt with is the positive obligation, one has to take into account questions of proportionality. And we derive that from the key in paragraph 78.
Right.
And my lords, we say the context here is family, and so the family judgments are instructive, and the understanding that one's balancing Article 3 and Article 8, and that it's important that children are brought up in the family is recognised by Section 17(1) of the Children Act 1989. But can I take you to tab 47, please, before I go to those family judgments?
Can I just ask you a question about Munjaz before you leave it?
Yes.
At the end of that, it says, as the court said in Z in the UK, states must take measures to provide effective protection of vulnerable persons. These must include reasonable steps to prevent ill treatment. Then does that not bring you full circle back to Ms. Gumbel's point about sometimes making an assessment of whether the local authority had acted reasonably, albeit in the context of human rights?
In Z, the complaint was a failure to remove.
Right. So you say it's because of the pleading of that, and therefore.
At 47, you've got the United Nations Convention on the Rights of the Child, which my learned friends rely on in their scouting. And they take you to...
Before you go there, let's just double check where we have got it. Because the file's gone slightly haywire at the end. 47.
Yes, divider 47.
47 is HXO in my bundle.
What about 48?
48 in mine.
47.
I had to reconstitute, so I apologise if I've...
Mine's 47. So.
Okay. So my learned friends rely on Article 19, which you have at the top of page 1536. But in our submission, that needs to be read looking at the other requirements under the document. And if we look at the preamble, page 1532, one looks at the fifth paragraph down, starting convinced. Convinced that the family is the fundamental group of society and the natural environment for the growth and well-being of all its members, particularly children, should be afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community.
Why do we need to go to this convention?
Well, because my learned friends rely on it, and they rely only on Article 19. And in our submission, that takes it out of context, because it replicates the issues in the...
We've been warned, haven't we, the dangers of relying on unincorporated human, international instruments. And the point you're making is well covered in domestic law, isn't it?
Well, then I'll leave it. Can we then go to MA, please?
Yes, interesting, that's the family case you cited.
Oh, I'm so sorry. 28.
It's a case where two family judges seem to have disagreed.
My Lords, the questions identified at paragraph 47 by Lord Justice Ward, and then from paragraph 49 he cites the well-known judgment of Mr. Justice Headley in Rael care threshold criteria.
Yes.
Who himself cites
Lord Temple.
and then goes on to say, those who may regard the last sentence as controversial, but undoubtedly represents the present state of the law and determining a starting point, it follows inexorably from that society must be willing to tolerate very diverse standards of parenting, including eccentric and barely adequate and inconsistent. It follows too that children will inevitably be very different experience of parenting and very unequal consequences flowing from it. It means that some children will experience disadvantage and harm, while others flourish in atmospheres of loving security and emotional stability. These are the consequences of our fallible humanity. It is not the province of the state to spare children all the consequences of defective parenting. In any event, it simply could not be done. And then, I'm not going to read it, but if what my...
Well, 51 is important as well, isn't it?
Yes, I was going to ask you to look at that.
Should we just remind ourselves of that?
And again, on a similar note, my lord, paragraph 53, please, citing Lady Hale. And again at paragraph 54, rather than Lady Hale, just Lord Justice Ward, please.
Yes.
I say rather than Lady Hale because I'd be very grateful if you would go back 2 tabs to 24, where we have Ray B. Sorry, that's wrong. 26, my apologies.
26.
And could we look at page 759? Children have both the right to life under Article 2 and the right not to be subjected to torture, human degrading treatment or punishment or under Article 3 of the European Convention. States are required to take measures to protect them, principally in the form of effective deterrence through the criminal law, but also through taking steps to remove them from an abusive situation about which the authorities knew or ought to have known. Z. There's nothing in those cases to suggest that the authorities are failing in their duty to protect children from human or degrading treatment because they're unable permanently to remove children from their families on the basis of unproven allegations. Deterrence through criminal law depends on proof of the criminal standard. The duty to take positive steps depends on the authorities having reasonable notice of the risk. See Osman. For a risk to be real, it has to be founded on real facts, not unproven speculations.
Well, the passage of Re B, which you took us to as quoted by Lord Justice Ward in MN, ends with the question, paragraph 22 of Lady Hale's judgment in Re B, which she answers in the next sentence in paragraph 23. So if you go back to 744, just in case there's any doubt about it, a likelihood of significant harm, future harm, has to be based on proven facts established on a balanced probabilities.
And my lords, I ask you to look at Ray B as well for paragraph 78, because in MA, Lord Ward, I think, misses out, I think it may be the last sentence.
Say again, 58.
78, my lord.
Sorry.
He cites the first part of it, but he misses out the last sentence, which I think goes to the point my lord has just made.
Yes.
So, my lord, we say in this context, first of all, and I suppose that's the relevance of the human rights, the child's rights that I referred you to, there has to be a balancing of Article 8 and Article 3. Secondly, it is clear that not all forms of bad parenting give rise to significant harm. There has to be a wide margin. Thirdly, it's our submission that significant harm and an Article 3 breach are likely to be very similar. I don't accept what my learned friend says, that Article 3 breach falls far below significant harm.
Did you say far below? She said it was a lower threshold.
I don't accept it's necessarily a lower threshold. It seems to me, it's our submission, rather, my apologies, that if someone is suffering inhuman and degrading treatment and there is a real and immediate risk, then you need to consider intervention by the state. It doesn't necessarily have to be removal, but you'd have to consider intervention by the state. And I emphasise the word consider. And if that's right, you can't set the minimum severity threshold so low that you are in a position that bad and inconsistent parenting, which is what was found here by the judge on the basis of the summary judgment facts before her, if you set the threshold that low to answer the question you addressed to my learned friend, then you do open the floodgates. And the fact that local authorities spend lots of time investigating and settling claims is not an answer to that. That doesn't mean that there are not cases of serious neglect, of which Z is one and E versus the United Kingdom are another, where there are breaches of Article 3. It's just here that the minimum severity threshold hasn't been passed and there isn't a real and immediate risk.
Nobody's taken us to DP, but the...
Yeah, I was about to.
Oh, you're about to, because that really seems to summarise what you're saying.
Yes, it does. You're quite right, my lord. So I wanted to deal with the family authorities and then go to DP. So now I have to locate it.
Tab 16.
Thank you so much, my lord. And it's, I think, 113 and maybe 112.
Yep.
So in DP, you have a situation where the two applicants have been sexually abused by a stepfather in C. There has been other significant other treatment which was of concern, but the authorities could not have known of the sexual abuse, which obviously would have breached Article 3.
So they didn't know about the sexual abuse, but there were other things. There were the 4 incidents of violence.
Yes. Well, we see them all set out in some detail at the passages marked.
Yeah.
From 112, really, we can see a number of instances, you can say, some involving poor parenting and neglect, some involving physical abuse, some involving lack of proper care.
And 4 involving violence.
Yes. And what the court says is, and if I can take you to page 405, about 10 lines down, the court is not persuaded, therefore, that there was any particular aspect of the turbulent and volatile family situation which should have led social services to suspect a deeper, more insidious problem in the family. Now, I accept, if one then goes to 113, nor can it be regarded that social services, due to the ongoing problems of the applicants within the home, were under any obligation imposed by Article 3 of the Convention to remove them into permanent care. The court has had previous occasion to acknowledge the difficult and sensitive decisions facing social services and the important and countervailing principles of respecting and preserving family life. While there were times when both applicants showed significant distress in the family environment, both also showed strong ties to the family. After the first applicant was placed in temporary foster care in May 1980, she returned home at her own request. Last sentence, please. For the social services to be justified in taking the draconian step of cutting permanently both applicants' links with the family, their family would have required convincing reasons which were not apparent at the time. And so it's our submission that that really reinforces the approach taken in MA and Ray B, and this kind of turbulent and volatile parenting, as it was described there, is not sufficient to reach the minimum threshold.
So how would you compare and contrast significant harm on the one hand, likelihood of significant harm and a real and imminent risk of inhuman or degrading treatment? Do you say one is significant harm is, you don't accept that the Article 3 test bar is lower? Do you say it's higher than significant harm, or that it overlaps in some cases but not others? How would you put it?
I think we describe it as, it would be too mechanistic to say the same, but there is a level of similarity between them. If anything, I suspect significant harm might be slightly lower. Because I think if you've got if you have inhuman and degrading treatment, which breaches the Article 3 rights, then at the very least there would be an obligation on the Social Services Department to consider some form of remedy. And if I'm right that the poor parenting described in L threshold doesn't constitute significant harm, in my submission that would map on to Article 3 being more severe. And I think you get that also if you think about the next stage of the test, which is real and immediate risk. And you haven't been taken to Osborne, and I don't necessarily want to, because we all know, we're so familiar with paragraph 116, that Osborne sets a high bar because of the need to recognise the diversity in society and not placing an undue burden on public institutions, in that case the police. And the same must apply for social services here. If you set a bar for Article 3, which is lower than significant harm, it follows that you are setting a bar which requires intervention in circumstances of less concern than under the domestic law. And we're told that the domestic law does properly protect the Article 3 rights and balance system of Article 8. And you are also placing an undue burden upon local authorities, because they're going to have to go in lots of circumstances which may equate to what Mr. Justice Headley is describing in Rael, and get involved because it's Article 3.
Because I'm a human rights person rather than a family law person, I just wonder whether it's simpler. There's one thing which is Article 3, there's a quite different thing which is Section 31 of the Family Act. The one is interpreted in accordance with Strasbourg authority and the other is a domestic course. If there was to be a breach of Article 3, it may well be that you would treat it as significant harm for the purposes of making sure they've got the power to ensure there is no breach of Article 3. If Section 31 couldn't possibly be interpreted in that way, then there'd be a failure to have in place a system that takes care of people suffering ill health, ill treatment. But that's just a fashion way.
I suppose going back to the care and control point, which we abandoned, and I said the reason was because we acknowledge that the 1989 Act is the way that the state discharges its obligation to create a structure for the protection of the Article 3 rights. And if that's right, then if Article 3 is lower, it hasn't done that. Because there's the two operational obligations. One, a legal system, and two, the positive obligation to take steps. And our submission is that if the Children Act 1989 requires more than Article 3, then there's no structural protection. And the state's failed in its operational duty, which my learned friend doesn't allege. But that's why we make the concession and care and control, and that seems to me would be a consistent approach. And it also seems to me what Baroness Hale is saying in Ray B. I hope that answers my lord's. Can I turn to a real and immediate risk, please? And I've identified Osmond. We also go to Van Cole. Van Collie, I'm told, by my learned friend Lord Folks, who appeared in the case. So I'm simply going to take you to the parts we relied on, let him deal with it in more detail. Thank you. Divider 25, please. And it's page 715, paragraph 66 and 67, the first sentence. And my lord, I also would ask you to consider paragraph 70, please, over the page. And my lords, what we take from that is an objective test, a test that is clear, that has a high threshold, that isn't altered, and what one has to consider high threshold in each factual context, but the test itself doesn't alter. And my lord, can we then take you to Lord Dyson, please, in Rabone, which is divider 31. And at page 855, the test is higher than negligence, not dependent on reasonable foreseeability at paragraph 37. And then at paragraph 39, as whoever the risk was immediate, Miss Carr-Frisk submits that the Court of Appeal failed to take into account the fact that an immediate risk must be imminent. She derives the word imminent from Lord Hope of Craighead in Van
Cole.
Thank you. Collie, I'm sorry.
Collie, sorry.
In Ray Officer L, Lord Carswell stated that an apt summary of the meaning of an immediate risk is one of which is present and continuing. In my view, one must guard against the dangers of using other words to explain the meaning of an ordinary word like immediate. But I think the phrase present and continuing captures the essence of its meaning. The idea is to focus on a risk which is present at the time of the alleged breach of duty, and not a risk which will arise at some time in the future. And it's our submission that if one looks at the 7 events pleaded against Birmingham City Council, they are neither present or continuing, nor can you be sure that they are risks which are likely to event thereafter. They are sporadic events over a period of time. There is the 20-month lacuna before the point at which, in July 2008, at which it said the charge should be removed. But we stress the last sentence, present at the time of the alleged breach of duty, and not a risk that will arise sometime in the future. So if the breach here is the fact that the court isn't considering care proceedings from July 2008.
Yeah, it's not helpful to talk about breach, actually. It's really treatment.
Repeating
Equivalent.
itself.
Yeah.
So if the question is, in July 2008, would the treatment be repeating itself, so the court would remove, then it's our submission that, first, because they fall below the threshold, but even if they don't, you can't, on these 7 events over this period, consider there is a real, immediate and continuing risk.
So you then say that here again, the test is, the bar is higher than it is under section 31. Do you? Where because there it's the child is suffering or is likely to suffer. Likelihood being a real possibility.
Yeah.
And a real and immediate risk, you said, is, without being analysing it too fussily, is a higher hurdle.
I do, my lord, and can I try and illustrate it in this way? I can see that you might have concerns about a parent because of their inadequacy, and you might, as a social services department, look forward in the future and say, as this child grows, possibly because of learning difficulties or something like that, you're just not, whatever support we provide, going to be able to meet the needs. And you could see there'll be psychological reports and assessments, and you might then think we're going to have to remove the child. But that's and so that's why I say there may be situations where you don't even need the Article 3 breach.
Well, the section 31 is not just about care orders. There are also supervision orders. So it's the threshold which has to be crossed for any statutory intervention, i.e. supervision order or care order.
I of course accept that, my lord, although again, coming back
Which
to
again,
facts of this case.
yeah.
It seems to me it must be a care order rather than a supervision order that's sought by the claimant.
And there are a significant number of children at the end of care proceedings who are still at home and in a number of cases under no order at all.
But again, in this case, it's removal. But that's why I say it's a more significant risk, because what you're saying is you need to intervene because this child is suffering inhuman and degrading punishment or treatment.
It's real risk, real immediate risk. If the mother rings the social services, I can't stand him anymore, I can't go on. Once he comes out of school, I'm going to kill him. That would be a real immediate risk. It's not immediate in the sense if he's in school till 4 o'clock.
No,
but it's present. She's threatening him. It's real. They believe that she's going to carry it through. Yes. Sounds like it. And it's in Article 3.
And my lord, that brings us to another point in dispute between the parties, which is how the judge assessed it here. And I'll come to that in a second. But I absolutely agree with you. If a parent is threatening serious physical harm or serious sexual harm, but it hadn't yet eventualised, then of course there would be a real and immediate risk.
It could be a real and immediate risk. Similarly, if there wasn't a future immediate threat, she hadn't run the social worker said he's going to get it when he comes home. But every day, for the last 7 days, she is beaten in black and blue within an inch of his life. The fact that she hasn't said, I'm going to do it on the 8th day, it could still be a real and present.
Of course, it's what they knew or ought to have known, assessing the situation. And at paragraph 60, 2 of the judgment, page 60, one of the points of appeal is that this is said to be a failure to get the test right by Judge Obi.
I'm sorry, I summoned my red book, my
Yes.
court practice, in case you started getting too technical.
Well, I saw it and thought, now I'm in trouble.
Yes, no. Sorry, where are we going now?
Paragraph 62, which
Of the judgment.
of the judgment, yeah, which ties in with the question I was just asked by my lord, because it said that this is a misdirection, particularly what's said in the last sentence there. And it said that that undermines the judgment.
Right.
But in my submission, that needs to be read in conjunction with paragraph 75 at page 65. And we say that what's said at paragraph 62 is a response to the slightly odd way this was pleaded. Because given that the pleading is, 1, there are 7 instances, all of which are ill treatment or degrading treatment, and 2, there was a real and immediate risk. All she's saying there is, given your case, is that there's a real and immediate risk of that there is ill treatment. That's what I have to decide when considering whether there's a real or immediate risk. And we deal with that giving examples at paragraph 33 of our skeleton, which is at pages 212 and 213. while dealing with real and immediate risk, so we make those points there. Our position is that in this case, the claimant's submission was there have been Article 3 breaches, and when she came to consider real and immediate risk, the learned judge said, I'm going to consider whether there have, and if there have, that will inform whether there's a real and immediate risk. She wasn't saying, I have to be sure it's going to happen sometime. She accepted that it was enough that there was a risk of that in the future, and those are what our points A to E seek to address. Dealing with real and immediate risk, it's important not to operate with hindsight. And at paragraph 26 of our schedule, our skeleton, page 209, we identify two citations from Lambert, paragraph 246 in DFX. And because that's such a similar case, it seemed helpful to illustrate there that she didn't approach it on the basis of hindsight, but also paragraph 33 of the judgment of Lord Hope in Mitchell. And again, dealing with the Osman point about the threshold for real and immediate risk, we rely on X versus Bulgaria, which is again a case about children.
Yes.
And paragraphs 181 to 183. I'm not sure I need to take you to them, but we'd ask you to look at those references. I think there are three further points which I need to deal with, please. The first is my learned friends place reliance on FO versus Croatia. We say that that's an Article 8 case, not an Article 3 case. It's specifically said not to be Article 3 because it involves insults rather than inhuman or degrading treatment in either a physical or psychological sense. And so we say the reliance on it in this case is not apt. The point about medical evidence, if you go back to the pleading, the medical evidence or the medical conditions that the judge was asked to consider are those in green in paragraph 8. So we see that at page 93. So the original pleading was the claimant suffered psychological injury. He relies on the report of Gillian Evans, which was a report in the care proceedings with which we were not served. But then he adds the three diagnosis, psychiatric diagnosis, post-traumatic stress disorder, borderline personality disorder, and a contribution to Asperger's, on which the claimant relied at the hearing, which he said he needed treatment for, and which it was said was supported by the report by Professor Fox, but that was never served.
So Professor Fox has never been served, and neither the judge below nor this court has seen Professor Fox's report.
We've never seen Professor Fox.
And Gillian Evans?
That would have been in the care proceedings, so Worcester will have it, but I don't think Birmingham City Council will ever have it. So I'm corrected, maybe we have seen Gillian Evans. I'm sorry. My learned genius says she has seen it, so she must have seen it at some point.
But it's not been put in evidence in this case. It wasn't put before Mrs.
It was not
Deputy
before
Judge Obi.
Deputy Judge Obi.
Yeah.
Did anyone ask for Professor Fox's report?
I think certainly we would. I think as I remember the request from my learned friend Lord Fox was referring to. I think certainly the first respondent did ask for it, but I'll be corrected if I'm wrong. But the point made in the appellant's skeleton is, if you're looking at the threshold, you have to look at the consequences, and we pleaded the consequences, and that was enough. It wasn't incumbent upon us to support them with a medical report. And we say that is wrong, particularly in the summary judgment application, where we'd served our evidence and they had ample opportunity to respond and didn't. And we just simply don't know why that report wasn't in front of the court. And I suppose coming full circle and returning to where I started.
And do you have to, I can't remember now, do you have to serve it at the time that you serve your claim form?
It's a requirement under CPR 16, the practice direction, that you're, in a personal injury claim, you serve medical evidence.
And is this a personal injury claim for those purposes?
Yes. I mean, it is a claim, he's claiming that the article-free treatment has caused him psychological injury.
And therefore it's a personal injury claim even though it's Section 7 of the Human Rights Act?
Yes.
Okay.
It's because a personal injury...
Negligence claim to start with.
And my learned friend Lord Folkes points out that originally it was also pleaded as a common law claim. On an aside, it's suggested that the common law claim may be revitalised in a note in the appellant skeleton. So far as Birmingham City Council is concerned, I'd remind my learned friends in the court that they served a notice of discontinuance against us of the common law claim, which is in the supplementary bundle at page 44.
That doesn't stop them necessarily starting again.
Of course not, but what it does stop them doing is repleading it here. Final point, my lords. As I said, summary.
They're relying on the consequences as an element of why they say it's sufficiently severe, and you say, well, if that's the case, they need to produce evidence on a summary judgment to show the consequences.
That's absolutely my point, my lord.
Yeah.
Can I take you to divider 27, please?
Of authorities or...
Of authorities.
Bundle 1.
Yes, my lord, I believe so. And this is a time-honoured digit, paragraph 15765, dealing with summary judgment. And I'd like to take you to the last of the Roman numeral 7. On the other hand, it's not uncommon for an application under Part 24 to give rise to a short point of law or construction, and if the court is satisfied that it has before it all the evidence necessary for the proper determination of the question, and that the parties have had adequate opportunity to address it in argument, it should grasp the nettle and decide it. The reason is quite simple. If the correspondent's case is bad in law, he will in truth have no prospect of succeeding on his claim or successfully defending the claim against him, as the case may be. Similarly, if the applicant's case is bad in law, the sooner it is determined, the better. If it's possible to show by evidence that although material in the form of documents or relevant that would be put the documents in another light is not currently before the court, such material is likely to exist and can be accepted to be available at trial, it would be wrong to give summary judgment, because there would be a real as opposed to a fanciful prospect of success. However, it's not enough simply to argue that the case should be allowed to go to trial because something may turn up.
But is this a point of law or construction? This is really whether on the facts, the treatment that occurred and is said to evidence the risk was A, B, C and D. So is it really the sort of summary judgment case that...
In my submission it is, my lord, for this reason. It's a point of law or construction on the evidence before the court. And the Court of Appeal there go on to consider evidence. This is a point of construction and law on evidence, isn't it? In my respectful submission, what you're being asked to do is look at all the evidence that would be available to a trial judge and come to a conclusion as a matter of construction on that evidence, whether Article 3, minimum severity, and real and immediate risk are present on the facts. Because going to trial for the reasons I started out with, it's not going to get, there's going to be no different factual scenario. So you look at the pleadings, you look at the evidence, and you decide whether, in this case, there's a real prospect. And it's quite usual for summary judgments to be given in circumstances where both parties provide some facts, and the court then applies the law to the facts.
Well, you have witness statements, presumably documentary evidence, and then they decide on the basis of that.
Well, that's exactly what's happened here, my lord.
Yes, although that doesn't necessarily mean it's a point of construction within the way it was set out in that judgment.
No.
I think that is intended to cover statutes and documents. But
Short
anyway.
points of law.
Yeah.
So discrete I think that Lord Justice Lewison is making.
We are dealing with a point of law. You may feel it's not quite as short, but we're dealing with the applicability or the threshold for Article 3 in the context of the family.
Well, we know what the threshold is. We've got dozens of cases telling us. What we've got to decide is what happened here, and did it pass it?
Yeah.
Was there a real immediate risk of inhuman or degrading treatment?
Given what had happened in the past.
That's the question. It doesn't put like that. It doesn't sound like a legal question.
I think that there's three, going back to my 3 points. One, does it pass the threshold on the facts? Two, is there a real immediate risk? And coming back to my lord, you identified that if there had been black and blue but no threat. So if these are black and blue, then there must be a real immediate risk. If they're not, very unlikely to be. And finally, would there have been a removal?
Well, there's a fact. It's not law, is it?
The last one is fact, yes. The other two are law.
Say we disagree with that and with all fact. Any useful case on summary judgment on questions of fact, where other than we mustn't have a mini trial, and if we think something else will turn up, i.e. if the situation was there is nothing else that's going to turn up and we therefore have all the facts, and it's not like a strikeout, we're not reading the pleadings and taking them at the highest, we're reading the documentary evidence and any witness statement, here it's only documentary evidence, and we can still give summary judgment if on those facts a court would not find as a fact that there was a real and immediate risk, or that the local authority should have known.
I've tried to summarise and identify the best of the 7 points in the Roman numerals in this case. But if you read the 7 together, it seems to me plain that if the facts are uncontroversial, at summary judgment, the court can make a factual finding.
I think that's a better point than trying to say that construction is not construction.
Yes. Always wise to read all of what Lord Justice Lewison says, in my experience.
So it's realistic as opposed to a fanciful possible success. That is looking at will it win or not. And you would say when you've had the records and the judge finds the fact that there's nothing else that's likely to emerge and no other allegations that are relied upon, and the only evidence is she's done it on these 7 occasions before, and that of itself should have alerted you that there's a real and immediate risk she is going to do something to this child which is so severe that there's a breach of Article 3. And you say on the facts there's not.
Yes.
And it comes into the other.
And we said she properly applied the test for us.
Okay.
It's taken me a long time to say something that simple. I apologise.
Thank you very much.
My lords, I will endeavour not to repeat the submissions that my learned friend has made, covering most of the main points I would have covered. May I just focus on 1 or 2 points, which I hope I can provide some assistance to the court with. The question arises, where did the judge go wrong? Did she go wrong? And there's been a certain amount of debate about the approach to summary judgment. And if we go to page 49 for Bundle 1, we see where the judge directed herself about the approach to summary judgment. She sets out at paragraph 24 the powers that the court has in CPR 24.2, and then
The whole of Lord Justice Lewison,
and then there it is, the whole of it.
not just point 7.
Indeed, that's why I was taking you to it, because there it is set out in detail, and it must be realistic as opposed to a fanciful prospect of success. A realistic claim is one that carries some degree of conviction, more than merely arguable, and must not conduct a mini trial. That's quite right. This does not mean that the court must take at face value and without analysis everything that a claimant says in the statements before the court. In some cases, it may be clear there is no real substance in factual assertions, particularly if contradicted by contemporaneous documents. However, in reaching its conclusion, the court must take into account not only the evidence actually placed before it, on the application for summary judgment, but also the evidence that can reasonably be expected to be available at trial. Now, our submission is really the judge had all that she could have had. There is this application which I've already dealt with, and I won't elaborate on what I submitted in terms of the 2 threshold documents. Our submission is they're not admissible. If we're wrong about that, we say it doesn't carry the matter
Any
further. Although a case may turn out at trial not to be really complicated, it does not follow that it should be decided without fuller investigation. It's possible and permissible on summary judgment. Thus, the court should hesitate about making a final decision without a trial, even where there is no obvious conflict of fact at the time of the application, where reasonable grounds exist for believing that a fuller investigation would add to or alter the evidence. On the other hand, it's not uncommon. On a short point of construction, this is the point we've covered. It isn't really, I think, properly described a point of construction what we're dealing with here. It is, however, as the learned judge said at paragraph 26, necessary to bear in mind the court's duty to actively manage cases to achieve the overriding objective of deciding that justly costs appropriate share of the court's resources while taking into account the need to allot resources. And if the court concludes that the claim has no realistic prospect of success, and the question arises whether there is some other compelling reason for a trial, it's bound to have regard to considerations such as saving expense, proportionality, and the competing demands on the scarce resources. So we submit that is an impeccable direction as to the correct approach, and one which I would respectfully endorse that this court should adopt.
Can I just ask a factual question?
Yes.
Did you serve any evidence on the application for summary judgment?
We didn't serve any evidence, no.
So what evidence is there in relation to your claim?
Well, the evidence was the social services records, which were available. Now, perhaps behind my Lord's question lies the fact that it is possible in some cases that you can actually put in evidence from witnesses in certain cases. But the problem about doing that is if there's a challenge to what one witness says, then it'll be argued that there should be a trial because another witness says something different. I mean, there were 2 planks to the application. First of all, that it did not disclose a cause of action effectively as a matter of law, and secondly, summary judgment. There is a degree of overlap. But where the facts are clear or sufficiently clear, it's not incumbent, we submit, on anybody to serve evidence, if it is possible, on that evidence that is available to the court to come to a conclusion.
Did you make an application?
To put in evidence?
No, for summary judgment. Is
Yes.
it in the bundle?
Yes, we made an application for summary judgment. I'll find the application,
Yeah.
but that was the case. And this was the application that was made, I think, by both defendants.
Well, I saw obviously the other application and the short witness statement from Mr. Donnelly. I just wondered if there was anything similar from your clients.
I can't immediately, but I will, of course, come back to my Lord with that application. It's a supplementary bundle. I'm very grateful to Alona Junior 117.
But if you take the first thing that happened when the family were in Worcestershire and the children were in the care of a particular person who's said to be alcoholic and living in poor conditions, and the police found this little boy and his brother wandering the streets at 10:45 at night, that's one thing. And it said, although there's a dispute, you can read the chronology in 2 ways. On one analysis, the chronology is saying they go away a lot of weekends, and there's one occasion where they stayed with this woman, but your opponents read it in a different way, and they say the inference is that it's a number of weekends. And do we not need to know? I mean, if this mother was consistently leaving this child weekend after weekend, whilst this woman was not able to go after, and she went off on camping trips with her boyfriend, isn't there a need for some sort of...
It may be that even if there were hypothetically to be a trial, it wouldn't be possible to be to be precise about that. But let's assume that what one can deduce from what is the evidence is that they were, certainly from time to time, at an unsuitable house. What did the local authority do? They prevented that situation continuing by intervening. And so if we're talking about a presumed violation of Article 3, once they were aware of the situation, they intervened and effectively removed the children from the source of clearly highly unsatisfactory situation. I was just answering my Lord Justice Dingemans' question. I think that does provide clear evidence that we did apply for a summary judgment as well.
Well, and in fact, you did put in a witness statement, albeit as part of the application notice.
Yes, I think that's correct. I anticipated that your Lordship was asking me in terms of some further witness from a social worker or something.
Or exhibiting the files.
Yes. But so the application, I think, was properly before the court. The judge directed herself appropriately as to how to view questions of summary judgment, and then went on to do so. And it is important to see how, in fact, she adopted if I might call it, a holistic approach to this case. If one goes to the very conclusion, which one finds at 73, the document, we see at paragraph 105, having gone through the various issues that were then before her, and of course some of them aren't before this court, the conclusion, the merits of the overall claim are poor and have no realistic prospect of success. She then says quite correctly, it would be difficult not to empathise with AB. There were a catalogue of reports in the social service records which raised a cause for concern and strongly indicate that parenting skills of his mother were inadequate. He may well feel that he did not have a good start in life, and he is now a vulnerable adult. So she was plainly summarising the causes for concern and the inadequacy and the catalogue of reports. So there's not a question of her, as it were, glossing over those various incidents and coming to the conclusion that she did. And her task, she said, has been to determine whether the claims as pleaded are viable. And in the circumstances, there is insufficient evidence that the various incidents reached the high threshold required to sustain an Article 3 claim. And she also said that Article 6 was a non-runner. That's no longer argued. So, given a difficult case, the learned judge in our submission approached the case in entirely the correct way, and in summarising the task that she had to perform. Turning to our skeleton argument, which is at page 181 of the core bundle, I won't labour this, but simply perhaps to highlight one or two aspects and one or two cases which I hope will bring the skeleton to light. I think the status has now been clarified. It is now properly before the court. We made the point, and this is at page 3, how it is very difficult. It's been to know precisely how the claimants put their case. There's never been a proper pleading. There have been various draft pleadings. What the judge had was, I think, a draft amended particulars of claim 5. And despite there being an application now to put in further evidence, there is still no draft pleading. There's no application to amend. So the Lordships are asked, as it were, to take this all into account, and that in our submission is not some mere pleading point. A defendant is entitled to know the case against it. We deal with the story, which I think is now reasonably familiar to the court, insofar as Worcester is concerned. The AB and mother and brother moved into a refuge in December 2011, and then they left the refuge in 2012. And she dealt with all of that. I don't think I need, because she in fact dealt in slightly more detail, but not much more detail in the course of her judgment with that. If we go to page 7 of our skeleton, I repeat that she set out the approach to this particular case. She also had to deal, of course, with what was then a live issue, which was the so-called investigative duty under Article 3, which she dismissed. Now, the learned friends have both mentioned the fact that clearly there was one aspect of her judgment, not her fault in a sense, which was, in retrospect, wrong, which is that there's no duty. The argument was no duty if somebody, as it were, is in the community rather than closely confined. And there is some suggestion that it would be helpful for future cases if the court, appropriately circumspect way, acknowledged that in the course of this judgment, which would help. The same also might be said in relation to the investigative duty which she dealt with, and whatever the outcome of this particular operational duty, what she said about the investigative duty, it was correct, it's accepted it was correct, and it would be helpful if there was at least...
So you'd invite us to endorse that, and what do you say about the care and control point?
I think, with respect the interchange between my learned friend and Lord Justice Lewis, which is an understandable caution not to go beyond what, as it were, arises from the facts of a particular case. But I think it would be useful if it was appropriately confined, if there was some comment to that effect, which would enable those conducting this sort of litigation. So I think we're probably more or less an item on that.
Emerged from that exchange.
Yes.
Thank you.
So we are, of course, concerned only with one issue, which is the operational duty, and we deal with this. The point that I've just been discussing at paragraph 22, we accepted. In fact, we didn't take the point initially. The Article 3 operational duty may rest on social services in respect of children living in their area who are not under their care or control. Of course, local authorities have parental responsibility for all children in a particular area, so they're all...
parental responsibility.
Well, they are the corporate parents. The local authorities are corporate parents of all children within their area. I speak from some experience as having a wife who has that very responsibility for one particular London borough. It doesn't mean that they're expected to do very much, but in theory they are, and of course all children...
Do they have parental responsibility?
It's not actually parental responsibility.
It's parental responsibility, yes.
It's not parental responsibility. They have responsibility.
Corporate parent, they're known as.
They've got statutory duty specifically to keep prevent a review in their area, to look after children in need and so on. It's not like the traffic warden seeing two people on the street.
No, no.
It is a local authority that's there to look after children.
That's
in the colloquial sense.
It's all set out in summarised in my judgment in HXA.
It is, and I learned a great deal from that judgment. The operational duty may rest on social services in respect to which having children living in their area who are not under their care and control, and we accept that that is the case. We also set out the Children Act 1989, and of course I hesitate to speak of the Children Act in any detail in the presence of such experts. But the question of significant harm has emerged during the course of argument. Whenever the word significant comes up in this law, judges occasionally incline to it means not insignificant, which I've never found particularly helpful, but that is one way of...
There was a lot of angst about what significant, when the Children Act came in, what significant harm meant. And when it isn't all harm to a child significant, somebody once argued, a distinguished paediatrician.
Yeah.
Anyway, do you have a submission to make on how that test relates to real and immediate risk of inhumane or degrading treatment?
Well, the observation made by Lord Justice Lewis, which is essentially the human rights approach, is one approach. The approach of the statute or even common law may be different. I made that submission to the Court of Appeal in Van Colley and Smith, which was heard at the same time. It was roundly rejected. However, the Supreme Court said, no, that is correct. You do look upon them separately. And so that one wants to be careful not to borrow from one to the other. What I would say is that the sense of urgency that is connoted by the real and immediate risk. Yeah. Significant harm is significant and it warrants intervention at various different levels because there are various options, of course, open to the local authority is one thing. whereas the real and immediate risk, present and continuing, it's said to be a high threshold, and part of the, as it were, the height of the threshold is derived from this sense of real urgency that's connoted. So to that extent, I would submit there is a distinction between the two. There may be an overlap, but there is a distinction.
Yes. And it's not helpful to think which is a more stringent test. It's just different.
It's different. Many of the same questions may arise, but we say that all the authorities, and my learned friend Sir Weitzman has referred you to many of them, stress how high the threshold is in various different contexts. And of course, the corporal punishment cases are perhaps of limited use in the sense that they're mostly dealing with whether or not a particular form of corporal punishment did or didn't cross the line. We're talking here about a family and a domestic situation. Sorry. The Children Act, which we set out at paragraph 24, we do deal with the question of significance, and we refer to the case of re-MA, which I don't think I need take you to. That was the case of the girl who was slapped, kicked, and by her parents, but was still found not to constitute significant harm. So that does connote the fact that it's slightly higher than any harm, so that there is a hurdle that has to be crossed. We also deal with the chastisement of children at paragraph 26.
Yeah.
But fundamentally, of course, we're dealing with inhuman or degrading treatment. And of course, although it's not fashionable to suggest this, the fact that it's bracketed with the word torture means that of itself it does have connotations of being something immensely serious. The jurisprudence in Strasbourg has, as it were, put a significant gloss on that.
Yes.
It's been interpreted. But
So would it be fair to say that in the early days of the convention, the fact that they were coupled meant that degrading and inhumane degrading treatment was coloured by the fact that it was coupled with torture, whereas latterly it's been decoupled to a certain extent. Is that a fair?
in some sense, I mean, they are the same word. They're not eustem generis, as it were. But on the other hand, this is the article dealing with the most serious type of behaviour as prescribed by Lord Bingham in that famous passage. So one should not attempt to lessen the seriousness of this. My learned friend Miss Cumble really sought to say, well, there are a number of children who have the misfortune to have very unhappy lives which may come to the attention of the local authority, and was tantamount her submission was to saying, well, almost all those cases where they come to some sort of harm will be a breach of Article 3. That may be overstating what she submitted, but not by very much, I would submit. And one should not, I respectfully submit, in any way underestimate the seriousness of a finding of Article 3 against a local authority, or indeed anybody, whether it's the police or whatever, given that its origins and even the way that it's been developed by Strasbourg and then by our courts, taking into account Strasbourg jurisprudence. The paragraph 28, we deal with what Amos summarised in human rights law, what it meant, relying on the well-known case of Pretty. A minimum level of severity involves actual bodily injury or intense physical or mental suffering. So it doesn't actually have to be actual bodily injury. I don't think the judge said that, although at one stage it seemed to be argued that she misdirected herself. I think if you look at the judgment overall, she isn't doing that. Intense or physical, where treatment humiliates or debases an individual, etc., etc. So the threshold is therefore a very high one. It may fall, abuse or neglect may fall within that description, and the most egregious example was given in the case of Z, which is the European a version of the case of X and Bedfordshire, which went to
Yeah.
the House of Lords 25 years ago.
Yeah.
That was a very, very extreme case where the local authorities seemed to do nothing, despite these children being in the most appalling circumstances. And the learned friend rightly referred to the description of this. It is not a typical, with respect, social services case. Sadly, as the court will well know, this sort of story, which we see reflected in the chronologies and the hair, is sadly not uncommon. And we should be dealing with, or respectfully submit, when we're talking about Article 3, of something that is really uncommon or egregious, like Z. Anything else would not be reflecting what Article 3 is directed at. The case involved physical, psychological abuse, need to show serious or severe neglect, clear pattern of victimisation or abuse, and we refer to DP in UK and to D versus UK. I'll move fairly swiftly over although we deal with it in our skeleton, the corporal punishment element of this.
Yes. Well, do you want to just deal with that point before we rise?
Well, what's clear is that it's a question of degree whether the courts in Strasbourg thought that corporal punishment did or did not cross the line. It depends very much on the facts. I'm not sure that it takes us very much further in looking at this particular case.
Yes. We're not dealing with corporal punishment.
No.
All right, so we're now going to get on to what you have to say about the operational duty, are we?
Indeed.
Shall we rise now?
Certainly.
I think we're going to finish within our day and a half, aren't we?
I think so. I'm probably expect to be about sort of half an hour, 3/4 of an hour at the most.
Just to know in advance, it might help me. I've been puzzling about your paragraph 35, I think it is. 35(1). And there are different, because I think I see it differently. I see it as a four-limb situation, real and immediate risk of treatment which will amount to sufficient severe treatment to be within Article 3. Authority knew or ought to have known and failed to take reasonable steps within its powers. So when I read 35(1), and I'm so obsessed with the taxonomy now, I think to myself, is Lord Ford saying leaving somebody in the care of an alcoholic and letting him wander around at night, and it's probably more than once looking at the chronology, is not of itself sufficiently serious to be within Article 3? Or is Lord Ford saying there compendiously, it's not real and immediate because they've addressed it? Or is he saying this isn't really something that calls for imminent removal because it's better to keep the family with the mother and try and keep an eye on them, and they think that they put them on the child protection register. So it could be one of three limbs or all three limbs, and pinning you down is interesting.
Well, I'm very grateful for the advance notice
Yes.
of that.
You've got 18 hours to think of the answer.
It's meant to be helpful.
Yeah, it is extremely helpful. I'm grateful.
Well, thank you all very much. I'm sorry that my lord and I have been coughing away at you. I hope we haven't infected you. All right. Thank you very much.